any aspect of these proceedings or for any other purposes while you're inside this courtroom. There are several motions that have been filed. I'm not sure. Several of them may not be opposed, just going through in order. Is there any opposition to the motion for bill of particulars?
No, Your Honor.
If I could just ask the clerk to just endorse paper number 15, allowed without objection. There were some motions that appear to have been filed prior to a day or two prior to the arraignment. So there's a paper 8, which is also a motion for bill of particulars.
Your Honor, I think they're subsumed by the later filing my brother gave me, and those are the ones I worked off. We've met about those and discussed.
So I'm going to, can I just have
Yes, Your Honor.
paper number 8 withdrawn?
I had filed at the very beginning of the case a request for bill of
So we
particulars.
can mark that paper withdrawn because it's superseded by...
Yes.
And,
Yes,
and
Your Honor.
15 is allowed by agreement.
And, and
16 is motion for rewards, promises, and inducements. Any objection to that?
No, Your Honor.
So paper 16 is allowed without objection. Paper 17 for discovery of prospective expert testimony, physical evidence, medical evidence, and scientific and forensic tests. Any objection?
No, Your Honor.
No objection to 17, allowed without objection. Now paper 3 and 5 motion for expert designation is 3. 4 for reports, logs, and memos, and 5 is scientific tests and records of examination. Can I mark those withdrawn? Those were the pre-arraignment filings.
Yes, Your Honor.
So 3, 4, and 5 are withdrawn. 17 is allowed without objection. 18, the motion to preserve evidence. We did enter a specific language on a similar motion in the case of Commonwealth versus Aaron Hernandez. Have you looked at the language in that motion, and is the defendant satisfied with that language?
I have not, Your Honor, but if I'm not satisfied with that language, I'll just come
I
back.
can tell you what it says if you want. The first paragraph orders the Commonwealth to preserve and not to destroy any and all materials, including but not limited to CD recordings, DVD recordings, physical evidence of any kind or description, and handwritten or word processed notes which are relevant to the case and are in the actual, constructive, or joint possession, custody, or control of the Commonwealth. Such materials shall include any and all materials obtained and prepared by law enforcement officials in jurisdictions outside Massachusetts working in conjunction with agents of the Commonwealth during the investigation of the case. And paragraph 2 is the Commonwealth is ordered to disclose to the defendant whether any automatic discovery has been destroyed, lost, or altered when and if it becomes aware of such, and is further ordered to request of the law enforcement officials or others from whom it is seeking said material whether any of the automatic discovery has been destroyed, lost, or altered, and if so, provide the details.
That's acceptable, Your Honor.
So the paper 18, the motion to preserve evidence, is allowed the order to track the order that entered in Commonwealth versus Hernandez, number 2013-983. And that paper 19 is a motion for list of witnesses and other information. Is there any objection to that? No. Paper 19 is allowed without objection. And on paper 20, paragraphs 1 through 19, are there any objections? Motion for discovery, which is paper number 20, is allowed without objection. And can I deem because it would appear to be included in this. The pre-arraignment filing was for motion for statements of co-defendants, motion which was paper 8, paper 7. Motion for exculpatory evidence, which was paper 9. Can I deem those to be withdrawn at this time?
Yes, Your Honor.
And paper 6 had asked for the names of witnesses the Commonwealth intended to call on. I assume that would appear to be in paper number 20. So paper number 6 is also withdrawn.
Yes, Your Honor.
And to the extent it seeks an order of probation records, once the witnesses have been identified, you can seek such an order.
Agreed.
And what is, have you filled out a pretrial conference report?
No, Your Honor. I think at this time, and I'll let Mr. McCauley speak to that, but I think at this time it may be a little premature.
Your Honor, like I've indicated in the other cases, we have some additional discovery, most of which I anticipate to have by the beginning of next week, Monday, and is to be sent off to the respective attorneys. So I discussed with my brother the filing of the conference report at the next date.
So you think by the 13th, so to the extent that you had not yet gotten reports from certain offices, you think you'll have everything by the 13th?
Everything that will be in our possession at that time, I've gone back and asked everyone any reports that have not been written, any notes that haven't been collected, anything else connected to the case.
And then when will you be in a position do you think you'll be in a position by January 23 to have a pretrial conference report, not, to sort of know whether there are going to be any discovery disputes and set a date for a pretrial hearing?
Well, the problem from the defense point of view, Your Honor, is I've been given over 200 discs, DVDs, CDs to go through, and we're in the process of going through that, but it is going to take some time, and I expect that to take me through the month of February to just go through the discovery that's been provided. And I understand there's more discovery that's going to be provided.
So you don't think until then you won't be in a position to know
I would say
what
probably,
motions you're going to be filing to schedule a pretrial hearing?
I would say probably early March.
For a pretrial
Pretrial conference report. Yes.
And so we won't be scheduling a pretrial hearing, you don't think, until that, a date for a pretrial hearing? Until
Right.
then, because you won't know till then what motions you're likely to file.
I believe that's the case, Your Honor.
I'm doing a sort of a, since the pretrial conference is really a scheduling and this defendant doesn't have to be present, I'm doing a telephone conference, pretrial conference in one of the other cases, February 27. How about the same date for a telephone?
I can do a telephonic conference.
We can do that at let's say 3:30 on the February 27. And then I would hope that the two of you would have met beforehand, and maybe you can both be together in a room when we have it. Have executed a pretrial conference report, and we can then set dates for any for pretrial hearing, any non-evidentiary motions that are going to be heard, and filing dates for any evidentiary motions and scheduling dates for
That's fine,
those
Your Honor.
motions.
I'll be
So if you can both talk,
with Mr. McCall's
right,
office.
talk beforehand and sort of come up with dates for filing of non-evidentiary motions, filing of evidentiary motions, pretrial hearing when we would hear non-evidentiary motions and a date for hearing the evidentiary motions.
Thank you. That's fine.
Thank you. Obviously, if anything comes up, if there's a discovery dispute that needs to be heard, then I would, if you, we can fit that in at some point. But February 27 then for a pre-trial conference. Thank you.
Your Honor.